May it please the court. Jonathan Gressley from Jacksonville, here on behalf of Ms. Venn, the appellant, the respondent below. I'd like to reserve 5 minutes for rebuttal. I'm joined here today at council table with Bill Gressley, who was on the briefs. The dispositive issue here today is the petitioner below presented no evidence to the trial court that Ms. Venn stalked him. At the final hearing, the only statement he made that at all addressed his petition was a response to the trial court's question, is everything in it true and correct? And he stated, yes, ma'am. This is not competent substantial evidence.
Well, let me ask you, why is that not, given that Ms. Venn, who wasn't represented, neither parties were represented, but she didn't object to it. So if I write out a statement, 3 pages, hand it to the judge and say, Judge, this is everything that happened, to save you time, I've written it all down, and the other side doesn't object to it, I say everything here is true and correct. It's hearsay, but it's evidence, right?
And Judge, she objected initially to entry of the injunction, and
I've got the transcript. Mr. Fowlkes, is everything you put in your petition true and correct? Yes, ma'am. And then the court goes on, all right, Ms. Venn, more recently, and she talks to her. But Ms. Venn didn't object to, you know, like, as counsel, I'm sure would have if she would have had counsel. Your Honor, we object. That's hearsay. We prefer testimony from Mr. Fowlkes.
Well, him stating that it was true and correct is something that he had to do under the statute. When he signed his petition, as section 784-0485 subsection F says, that if you're going to submit one of these, you have to state that it's true and correct. And it was true and correct, he stated, as to the allegations that he put in his petition.
But what about my hypothetical where somebody fills out 2 or 3 pages, says, Judge, everything here is true and correct. I know you're pressed for time. Let me hand you this, and you can look over it later and make your decision, but I swear it's true. Other side doesn't object. That hearsay is admissible then, right?
I would argue no, and even if it was, that couldn't be competent substantial evidence on which to base one of these injunctions. She didn't consent to the entry of it, and I believe this issue has been resolved in the Newsom case. This court issued it about a year ago, and in that case, the petitioner appeared before the trial court, and the trial court essentially exactly asked if she still wanted the injunction.
Yeah, that's a little different there. Do you still want the injunction? Not is everything in this document that you're submitting true and correct?
And I would argue even in Newsom, that would even be a more relevant statement. He had, in order for him to file this injunction, he had to already say that it was true and correct. So that was a second statement.
Well, you're hung up on that, but I don't think that really matters. What about if there's just a piece of paper? I swear that everything in this paper is correct. Or here's an affidavit. The affidavits get submitted all the time, but the other side doesn't object to it.
She did object to entry of the injunction.
But she didn't object to the evidence at the hearing.
But that could not constitute competent substantial evidence. It's got to be more than some mere iota. There has to be some relevance to that. He was just saying it's the allegations I've made.
Why is hearsay, unobjected to hearsay, not competent substantial evidence?
He simply said what my allegations are true. He did not put forth any prima facie case or any actual evidence or allegations that he repeated to the court.
Let's assume we don't agree with you on that, but just for the sake of argument, you don't have to concede it. So, based on the affidavit, tell us why that was not sufficient.
The petition here is merely
the petition.
Excuse me, the petition. The petition's merely allegations framing the argument, and it serves 2 purposes here. You can have entry of a temporary injunction, but we're going to proceed once that's filed to a final hearing where the burden is on the petitioner to prove his case, and he has to present some evidence.
But I mean, assuming that everything he wrote in that petition is accepted, as my colleague has said, it was not objected to, it's competent evidence because it was unobjected to, and he said it was true. Tell us why those allegations are not sufficient to support the stalking injunction.
The allegations
about going to Bono's restaurant and spending time there, I assume all that's in there.
And Your Honor, I want to, if we accept this position that simply saying it's true and correct.
I just said for the sake of argument.
Okay.
Let's move to the merits.
If we accept that, then the final hearings in these cases are going to consist of a petitioner filing a petition, then the respondent being brought before the court, and it's going to be up to the respondent to disprove the case. The case law is clear that there has to be a full final hearing, and there has to be a burden on the petitioner to prove his case. If we accept that you can simply say it's true and correct in court or outside of court and submit the petition, and that will suffice for proving your case, then the burden would be shifted upon the respondent to disprove that, and we essentially would not have a full final hearing.
Let's move past that. Let's pretend that everything in the petition was, at the hearing, was testified to. If everything in the petition at the hearing was testified to by the petitioner, would she prevail here?
Would the petitioner prevail? Well, again, that he possibly could. The problem with this petition and the problem with not having the full final hearing here is that there's a smattering of irrelevant evidence in here. He states multiple things about the child support case, there's stale allegations, and then he presents a police report attachment that essentially contradicts everything he had said. But if we assume that he could have picked out certain areas that could have proven that she willfully, maliciously, and repetitively followed him or harassed him, certainly that could be the case. But he didn't present any evidence. And I would like to go back to Newsom, because there's an important point in the Newsom case.
So let me just get this straight. If this would have all been testified to, if each of the lines of the petition would have been testified to at the hearing, then there would be evidence that would support the injunction.
There potentially could have been. I believe that there was a contradiction in the evidence included in the police report that created some type of conflict. But again, he didn't testify to that. That was not offered into evidence. And I
think this happens in these cases.
I
think trial judges, you raise an interesting point here, because I think in these stalking cases, this is happening. Petitioners show up, they're asked in a cursory fashion, I don't mean to be critical, but they're asked, is everything in the petition true? Yes, it is. Okay, respondent, what say you? Well, I don't think that's true. Okay, I'm granting the injunction. And you want us to hold that you have to present evidence, the petitioner has to present evidence subject to cross-examination, or there cannot be a sufficient basis?
Yes, Your Honor. Unless it's conceded to or agreed to, this court has consistently held that. You've got the Mantell v. Rock case, but in Newsom, simply saying you want an injunction is not evidence. There are serious constitutional implications behind these injunctions. So there has to be a full-blown hearing. The law is clear on that. The statute requires that. Cases require that. Due process requires that. The petitioner needs to show up and is required to by law to present a case and prove his case. And that did not occur here. He said nothing but it's true, and what's listed in there is true, and that is something that he had submitted.
You said specifically in your brief that there was a lack of evidence that the respondent's conduct caused the petitioner substantial emotional distress. Was there nothing about substantial emotional distress in the petition, or is there something about the lack of substantial emotional distress? Is there something about the lack of substantial emotional distress that is a problem irrespective of the problem that you're focusing on here today, the petition?
Irrespective of him proving the case,
That's right.
I think he should have alleged it. And he would have had to have proven that at the final hearing, because if he's proceeding under harassment theory, he has to prove that there was substantial emotional distress from a course of conduct and it served no legitimate purpose.
But does the petitioner have to testify, I've suffered substantial emotional distress, or is it enough that she keeps coming to my work, she trash talks me to my employees, she knocks on my door at 4 a.m., and any reasonable person, therefore would be distressed by all that?
It's potentially there could be an inference, but again, that wasn't testified to, and there was no evidence of that. And right on that point is the Roach v. Brower case out of the second DCA. And in that case, the petitioner actually put on witnesses and had them testify, but what she failed to do was testify herself and offer some evidence to the court that she had suffered that substantial emotional distress. And on review, the court actually accepted the trial court's findings that there had actually been willful and malicious conduct. But the fact that she didn't herself testify to suffering substantial emotional distress mandated reversal. And that is simply what happened here. Is there was absolutely no evidence presented. So if we accept the appellee's argument that somehow allegations can equal evidence and allegations can equal competent substantial evidence, we've totally eviscerated any semblance
Well, I mean,
of
you have him under oath, right? He's under oath. He tells the judge everything in the petition is true. Now, obviously, it's very truncated, but tell us why that's not adequate evidence. I mean, she could have cross-examined him, right? And said, okay, by the way, you say in your petition, page 1, line 28, that I was at Bono's restaurant and that I trash-talked you to your employees. Now, Mr. Petitioner, that's not true, is it?
And she could have actually been a lawyer, but if Frank,
that's-
no,
you and I both know that's not a reason.
that is not my argument. Frankly, once it became her turn once he had essentially rested by just stating that, there wasn't a case, there wasn't evidence that was sufficient for there to be an entry of an injunction here. She didn't need to do anything in this case. Had she rested, had she been a lawyer, she would have moved for involuntary dismissal or just rested, and there would have been no case, no sufficient evidence upon which the trial court could have entered the injunction. So there was no duty on her to actually present anything or rebut anything because he had not proven his case. Quickly on the due process violation issue before I sit down, there's also that there was not a real full hearing here. He presented no evidence. The trial court just questioned her, specifically, and then opened the floor for her to generally disprove her case. Once she tried to offer real testimony, the trial court cut her off and essentially orally granted the petition. That's similar to the David v. Shack case, where the respondents questioned and by the trial court, and then they entered before this is done.
Well, there's a lot of questions to and from and responses from her, and you seem to be objecting to some of the specific language where she talks about, can I put on my case? And the judge says no, and I don't have it exactly in front of me, but couldn't the judge be talking about her counter petition that was later heard and denied?
I mean, certainly the transcript is what it is, and my reading is she was trying to present some case. But even with the lack of time she had, the problem here is with him not presenting any evidence that specifically tried to establish his case and prove his case, there was nothing she could really rebut, nothing she could really cross-examine him on.
I don't recall in your reply brief you responding to the preservation argument. You want to briefly touch on that?
Could you direct me exactly to?
Well, the answer brief, the first argument out of the box, as I recall, is this isn't preserved.
No, they were. Oh, excuse me, Your Honor. I believe the appellee was making an issue about whether there was a lack of sufficient evidence, if there should have been a motion to dismiss. That was never an issue that was raised below, or it was never raised on appeal. So I believe that's entirely irrelevant for any issue we have here today. So the actual sufficiency of the evidence issue and the due process issue have been raised. Sufficiency of the evidence can be raised at any time on appeal, and that was properly preserved and raised, and the court can reverse on that purpose alone. I will reserve the remainder of my time for rebuttal.
Good morning, Your Honors. It may please the Court. I'm Thomas Burns, and along with Rebecca Creed and my associate Arda Goker, we represent Mr. Fowlkes. Judge Bilbrey, I think you started off exactly with the right point, which is whether the answer brought in all of the allegations of the petition, and it does, because there was no objection to that question. And it helps maybe if you break it down very simply. Imagine that you write one declarative sentence on a piece of paper, and then somebody asks the witness that question, is this true? And then the answer is given, yes, it's true. That fact comes in, that declarative sentence comes in. Now, it could have been objected to because it's a leading question on direct, or it could have been objected to on maybe some other ground.
Or that the trial judge is proving his case and potentially stepping outside of her neutral role.
Right, but none of those objections are made here. And so that comes in, and there's a Supreme Court case that, there's actually multiple cases that talk about that, but the idea is if there's no objection, that evidence comes in and it's not a fundamental error, as a general matter. So then the question really turns to what's in this petition, and are the allegations, the sworn allegations in the petition, sufficient to support, to constitute competent substantial evidence? And the answer is, of course, that they are. It is. And there's kind of a preliminary point that we need to address. On page 2 of the reply brief, Ms. Venn argues that this is a form that was concocted by the Jacksonville Sheriff's Office or by the clerk of court, and that's incorrect. This is a Florida Supreme Court approved form. Rule 12.000 talks about approving these forms, so does Rule 12.015B, and then the Supreme Court has repeatedly issued opinions with amendments to these forms over the past 15 years. I found at least 6 of them doing a search for it last night. So this is an approved form.
So your argument is that a petitioner can file a petition for temporary stalking injunction, go to court, the judge says everything in the petition true, yes it is, grant the petition.
That could happen. If there's,
It
did, and it could properly happen, I mean. But there's 2 keys there. One is that there's no objection, and there could have been an objection, and then you'd be reviewing an evidentiary decision. But that's not the type of case we have here. The other is that the judge does that, and the petitioner says, yes, it's true. And then the judge looks that petitioner in the eye and says, no, I don't believe you. I don't think that what you said is correct. And then the judge could go into further detail. I mean, these judges handle these kinds of cases all the time. They see hundreds, if not thousands, of witnesses, and they know how to tell when somebody's lying or when they're telling the truth. And so that's an appropriate thing.
And the petition will also have to satisfy the statute. So what are the 2 incidents here of stalking that cause substantial emotional
There's
distress?
multiple incidents. I'm sorry, I talked before you finished the question. There's multiple incidents that he describes, and it's really 2 courses of conduct. One that's directed toward his employment, and one that's directed toward his personal life. And as to employment, talks about her frequenting bonos, which she admitted to at the hearing, that she tried to get him fired, that she gossiped to all of his employees that he was supervising, that she cornered him at the restaurant where he had nowhere to go. He had to go to his office, and then she threatened to get the crackers on him, which I think the only reasonable interpretation of that phrase is that she, intended to have somebody violently attack him, a cracker violently attack him, and then that stuff is corroborated by witnesses in the petition. The letters written by Ms. Babity, who is the manager, and Ms. Brisbane, who's the employee. So that's the course of conduct.
So this went beyond showing up with her daughter to eat at the restaurant.
Right, and as we explained in our brief, she says at the hearing, "Oh, I was there because I was hungry," but that doesn't explain the lingering, and it doesn't explain the other conduct that she engaged in.
Well, I mean, certainly there's a course of conduct alleged that would meet the normal definition of harass. She's bugging me. She shows up a lot. I don't like it. I wish it would stop. But how do we get from the petition, which is the only evidence we have of this substantial emotional distress, how do we get that there's nothing in there about him saying, I can't sleep, or I can't eat. It's driving me insane. I've had to go to counseling. Something to show some true, obviously he didn't use the buzzword, I've suffered substantial emotional distress, but there's not even really a definitive inference of that.
I think there is a definitive inference from numerous things. One is that he has to buy all the security stuff. So he's like, I feel unsafe for myself, and I should take a step back. It's a reasonable person standard, and so here he's got threats of violence. He's got this constant conduct. He decides he has to get security stuff for his home. There is the threat to have the crackers get him, and then another threat to have his wife essentially murdered by a hitman who has a gun. And all of those things to a reasonable person would be extremely distressing. I don't think there's any magic word requirement that you say, I'm substantially emotionally distressed by this. You can infer from the conduct. And the same thing could happen with any kind of fact finder, whether it's a jury or a judge. Based on this conduct, you could infer that he was substantially emotionally distressed.
Are these parties in a different place than maybe most people because of what I understand from the record is that there's a history of injunctions, protection orders flying back and forth. There's child support, child support battle going on, and so this is all occurring within the context of lots of things flying either way.
I think that's correct. Yeah, there's a lot of stuff going on. It's a relationship that clearly is no longer functioning the way a relationship should be, friendship or whatever you want to call it. So that's our point really about sufficiency. This petition, whether you consider it an affidavit or just simply a statement of declarations that are there, it came into evidence as soon as he answered that judge's question, and there was no objection. And so the evidence supporting the stalking injunction is sufficient.
Well, you would agree that we can review the sufficiency of the evidence on...
That's correct. And we didn't make that argument in terms of preservation. It's Rule 12.530E, and that says that after a bench trial, sufficiency can be reviewed without there having been a motion for judgment as a matter of law at the close of evidence. So that's what we have here. We're just saying that to the extent they're arguing that the petition itself wasn't sufficient, that needed to be teed up in a motion to dismiss, and it wasn't. And so that's not reviewable. It is reviewable, but it's reviewable as fundamental error, and they can't establish fundamental error here for many reasons, including the fact that the petition itself is legally sufficient. So that, I think, it addresses most of the sufficiency stuff. So that's the petition part. But it didn't really just end with the petition, because Ms. Venn herself testified, and I think she really shot herself in the foot when she did that, because she told a series of stories that were fantastical and hurt her credibility. One of the the part that hurt her credibility said, I've never been to his house. Oh wait, no, I have been to his house, but it was only to deliver this one thing. Oh, I didn't know that was wrong because of some reason. And I think all those things made the judge question whether she was really telling him the truth. And some of those statements could be used as affirmative evidence that the injunction could be properly entered. She admitted going to his place of work and going to his house. So that's the point on sufficiency.
Would you like to speak on the various cases that were cited with regard to the evidence at trial and the petitioner's burden to do something?
Right, and the ones that I thought were most important were at least for the appellant, were Newsom against Newsom, Mantell against Rock, and Burns against Bockerich. And all of those cases involved situations where there was no evidence presented at the hearing. The closest that they came is the Newsom case, which they heavily rely on. But there the judge just asked, do you want the injunction? Didn't say anything like, can you please confirm the accuracy of the petition that you filed? And so that's the key difference. And that was what you had noted earlier, Judge Bilbrey, during the initial argument. That the judge doesn't ask that question confirming the accuracy of the allegations in the petition. Okay. Did you have any further questions about sufficiency, or would you like me to move on to procedural due process? I'll move on. So procedural due process, there's really three requirements. It has to do, like the witnesses, you have to have a full opportunity to prove or disprove the allegations, the initial pleading. That requires witnesses be sworn, parties be permitted to call witnesses with relevant information, and the cross-examination should be permitted. Here, neither in the trial court nor in the appellate court has the appellant challenged the idea that the witnesses weren't sworn. And there's actually a series of cases that say if you don't challenge the fact that a witness wasn't sworn, that's reviewed for fundamental error, and it is not fundamental error. I can give you those citations if you want them, or you can find them. All right, I'll move on. The second requirement is that each party should be permitted to call witnesses with relevant information, and that certainly happened here because at the hearing, the judge, first hears from Mr. Fowlkes, then interrogates Ms. Venn for a little while, and then after that says, okay, anything else you want to say to the allegations to this past year? That was her opportunity. That was her opportunity to call a witness, or it was her opportunity to say, look, I want to cross-examine Mr. Fowlkes on the allegations in his petition. I want to go line by line through everything he has said and have an opportunity to disprove this by showing that there's some internal inconsistency with his testimony. She doesn't do that. Certainly she's pro se, but that doesn't matter. Pro se litigants still have to follow procedural rules, and she did not do that. She had her opportunity. She didn't follow through with it, and that's where we are right now. So, like, essentially most of these issues that she's trying to assert now are reviewed for fundamental error, and she just can't prevail on that standard. Unless you have further questions. No. All right. Well, we ask you to affirm in all respects then. Thank you.
Your Honors, this is not a question about fundamental error. This is challenging the sufficiency of the evidence, which can be raised at any time. There was not a full hearing here. This cannot constitute a full and final hearing under any of the case law or any of the statutes. If this court is going to hold that just simply saying it's true and correct somehow incorporates allegations and makes it evidence, I don't know when there would ever have to not be an objection, because every single petition that's submitted to a court says it's true and correct. And this effectively, if that were to be this court's ruling, it would abolish these hearings. And these have serious constitutional concerns, freedom of association, Second Amendment implications. And if we abolish these hearings, which I believe that upholding this would, because all that would have to happen is simply saying it's true, and then the burden would be shifted to the respondent to disprove the allegations, I would please urge this court to at least write an opinion explaining to how these hearings can proceed from this point forward. And please help me distinguish the Newsom case, which requires that there actually be evidence that's submitted. There was never a claim in the brief that there was a failure to state a cause of action, and the appellant was challenging that. This is simply a question about the sufficiency of the evidence. And I will conclude if the court has no further questions.
Thank you very much. Thank you both for your arguments. The court will be in a brief 10-minute recess.